then we can take it from there.
Yep, that's us now live.
Okay, good morning, ladies and gentlemen, and welcome to a business meeting in relation to what will now be one of two compulsory purchase orders in relation to the the Denny Eastern Access Road. We have agents this morning, Jackie McGrath from Brodie's on behalf of Falkirk Council, Alistair McKeith and Angus Strathern on behalf of the Trust, and Martin Hall, Davidson and Robertson on behalf of John Taylor, with supporting colleagues from their council and firms respectively. I'd issued a suggested agenda in the course of last week to steer discussion for this business meeting, and I'll try to stick reasonably closely to that, but matters are moving on a little bit, I think, and I will be asked Jackie McGrath to say a little bit about the implications of that in terms of the second CPO. What I was going to say, just by way of introductory comments on this, is we have heard that Avant Homes, Alistair Sutherland and Bernice Paul was representing them at the last at the pre-examination meeting on March 26th, have now withdrawn their objection, and I see they've not objected to the second order, and so they're obviously not in attendance at this meeting, and that has some implications on the issues to be raised and how we take things forward on timings matters. The other issue to be aware of is at the last pre-examination meeting, Jackie McGrath had indicated that there was an intention to vote a second CPO, and I undertook to ensure, as far as possible, that when submitted to Transport Scotland, that should be passed through to DPA as quickly as possible, in order that I be appointed to deal effectively with the conjoined CPO. And I can confirm, I haven't actually seen the second CPO yet, but I confirmed that Transport Scotland have now confirmed they are in receipt of that order, and they're in the process just now of collating papers and passing those through to me, and I was in fact formally appointed last night, so now that bit of the process is now complete, and so that'll be coming to me, and we can deal with the implications of all of that for the procedural matters as we go forward in the course of this meeting and beyond. So that's an update from that perspective, which I hope is helpful to parties. So with those points being made by way of general introduction, I'll maybe hand to Brodie's to say a little bit about the progress on the second CPO and what the current position is as far as the interaction with the first one is. Thank you, Jackie.
Thank you, sir. As you say, the CPO has been promoted, notified and advertised, and a number of objections have been received. Those have been forwarded to Transport Scotland. Yeah. The Council has responded, and as at the moment, there are two objections which are currently maintained. One from the Trust, which is, Mr McKee will confirm this, I think relied upon the initial letter of objection that was submitted, although there were a couple of points that the Council wanted clarified, and perhaps we can go through that this morning, although as it turns out that may be not necessary. And the second objection was received from Mr Taylor, Lieutenant Farmer, and that has also been maintained at this point in time. Nothing further from Mr Gordon Jack, and no objections from any other parties, so no objection from Avant, as you say. So at the moment we have two objections in relation to the second order, and the two objectors are the same as those who have submitted objections to the first order, excluding Mr Jack. So that's where we are at the moment. Okay. And as we noted, you had been allocated as a reporter this morning, so I wasn't able to see any of the papers at all.
It's just not that bit of it as advice to parties, but sometimes the system is a bit slow to catch up. But that's useful that you are all at least aware of that as well. I mean, in practical terms, I suspect Mr Jack's objection to the first, although not formally objecting to the second, the same issues arise. So I suspect that there is a significant degree of overlap between the two, and we can treat that accordingly.
I think absolutely. Obviously, the land take, when you combine them both, is the same as it was in the initial proposal. So I think if we were responding, Mr Jack's objection will receive a full response in the course of time. And I think the Council, if you're just looking for an update, and that would be looking to submit a written response to you by the middle of July in relation to that.
Yeah, no, that's very helpful. I mean, we'll come in a little bit to the sort of the practical issues of when we look to have a hearing date and what the implications are just in a moment. I should say, in terms of timings, I'm conscious we're all moving into the kind of the remnants of what might otherwise have been a holiday season, and I certainly was hoping to be away for much of July, although that's now looking a little bit less likely. But I'm certainly not going to be around for the first 3 weeks in July, so other parties will no doubt be the same in terms of leave. We'll come a bit later on to talk about a potential date for a conjoined hearing, but obviously working back from that, we'll have to think about what's a fair period to be giving. In particular, I'm thinking of Falkirk Council, and I know there's a significant overlap between the two sets of circumstances. But with my appointment only yesterday, we haven't issued a relevant notice letter in relation to the second CPO. We'll do that in the next few days, and I think under the rules you're entitled to 8 weeks notice by which you should submit your statement of case in relation to the second CPO. Now that may well be very, very similar to the first, or it may be a modification of the first, or whatever. Certainly, without getting ahead of this meeting too far, I was inclining to ask if you could make sure you effectively treat that 8-week period as starting from today, which takes you to the 11th of August. And if you can do it earlier, then that would be absolutely fine. But that would allow other parties to see the statement of case, to see any differences that might arise there. And the same will apply, obviously, to statements of case from others. But the actual formal request for that will issue until next week, probably. So just to be aware of that. And as I say, we'll speak shortly about what that means for the date of the hearing. Concern. We'll progress that just as soon as we can. My other question, I'll go around other parties, and I'm going to start with Mr. Hall and then go on to Mr. McKee. My sense from the last meeting is that the implications of the second CPO were greater, or his concerns were greater in relation to that than perhaps other objectors. But I'm conscious that for Mr. Hall, I'm still awaiting his statement of case in relation to the first CPO. And I think when we spoke before, I recognised that there was a link between those two things. But I wondered if I could maybe ask Mr. Hall, first of all, for an update on his client's position in relation to what Ms. Maguire said for the two orders, but specifically in him, as I say, to give an indication as to when we'll expect to see a statement of case for the first order, let alone the second one.
Yeah, so thank you. Well, where we are is that we have a statement of case almost ready for submission. We've been delayed in almost cross-checking it with the second CPO, because there will be the statement of case will be the same for both. So it seemed to be premature to submit it for the first and then have to do another one for the second. So and I think at the last meeting you kindly offered to allow us to see the second one before submitting anything for the first. So that we're there or thereabouts, but we're also quite close to being able to lift our objection, hopefully. It was noted that some of the plots are now being removed from the first, and if we have formal confirmation of that, and along with some accommodation work elements, then I think we're in a position where our objection could be lifted and would drop away for both CPOs.
Okay. That's very helpful. And Ms. McKee, anything you would want to say by way of general introduction or comments on what you've heard?
Yes, thank you, sir. And sorry that you've just been appointed, because I sense that consensus is likely to break out quite soon. I've had quite a bit of discussion with Jackie Maguire at Brodie's over the last week or so, and I've also spoken to Martin as well. Where the trust are, and this in part impacts upon the tenant as well, but where the trust are is that we would wish to withdraw our objections to both of the CPOs, okay, subject only to the trust and the council entering into a form of contract that would deal with this temporary plot and licensing arrangement at the sort of front end of matters. Now, because that license arrangement concerns land over which there's an agricultural tenant, Martin's client would also need to be a party to that, and I understand that there has been some discussions about that, and he is minded to proceed on that basis. So where we are is that, subject, as Martin said, to sort of a formal form of words from the council to say that it's removing plots. I think it was from memory 4 to 9, 7 to 8, and a legal agreement. And Jackie and I have actually done a sort of similar agreement with Mansfield Estate for a Perth and Kinross CPO within the last 18 months. So there is a kind of model for that. My suggestion would be that we sort of put a stay of execution on matters for six weeks to enable the parties to complete that agreement and confirm that that has been completed to you, sir, the reporter.
Yeah.
I am able to say at this stage that the trust are not proceeding with their objection in relation to the access point, which was really the point which I think there was going to have to be a hearing or perhaps an inquiry.
Yes.
Nor is it proceeding with its issue in and around the sort of the funding of the Deer Road. So that is being completely
that's
dropped
helpful.
and can be treated as dropped from today. So what my submission to you this morning would be to allow a period of 6 weeks for that to be formalised amongst the parties. I'm confident it can be done within that period. That you acknowledge that the estate is dropping from its objection at this stage, as in today, its concerns regarding the access point and the funding. So therefore, there's no reason I can see that we need to go to a hearing, inquiry, or whatever kind of formal process. And even if, I suppose, even if parties do not proceed and reach agreement here, although I've expressed some confidence on it, I don't want to sort of jinx it. I still think that the matter, it would only really leave the matter of the temporary possession point, and that could be dealt with by submissions between Anderson, Strathern and Brodie's. So I don't think that's going to hold matters up. So that would be the thought, because I know you're quite interested in, so what's the fallback position, Mr. McKee? So that would be the fallback, but it would mean we wouldn't need some form of oral process to deal with that.
Okay, that's very helpful. Do other parties have any thoughts just on that as a suggested way forward?
As Mr. McKee says, we've had some discussions about this over the last week or so, and the council is keen to reach a negotiated settlement. Indeed, the council has quite recently issued draft license to Mr. McKee's clients, but we're quite happy to look at a different model. And we are familiar with the model that Mr. McKee has made reference to, so quite happy to go down the route of trying to conclude an agreement on the basis of that model. It's helpful that the other issues that were raised in the trust objections have now been dropped, and we're really just focusing on the temporary plots, because as Mr. McKee says, that would appear to, subject to anything that Mr. Hall has to say, remove any and the running of any tech confidence. And I would agree, if that is the only issue that remains outstanding between the trust and the council, then it could be adequately covered by submissions, written submissions, rather than having oral evidence on those points.
Okay, thank you, Mr. Hall.
Yeah, I think that fits with our thinking too. So we certainly would be comfortable with that approach if that was one adopted.
Yeah, no, that is very helpful. I was certainly thinking and reflecting on the meeting that we had at the end of March, when I think there was a recognition that at most a hearing is appropriate, and I was going to ask for confirmation that that view would remain so, even in relation to the second order, assuming it was, and that's certainly been confirmed. But if any outstanding matters can be dealt with by submissions, then that would certainly assist in the kind of processing. And the need to consider the full arrangements for production of documents and production of preconditions and the like. So I'm obviously content from that perspective to look in terms of kind of revisiting this in 6 weeks, which takes us around the sort of the first week in August, and reach a view at that stage then. And on that basis, there's no need to think in terms of kind of fixing dates or checking availability of dates later than that, or
Yeah.
working through other timescales. The only other issues that were in my mind, I think, is that there was a discussion, and I think that's mainly related to the trust objection, was the clarification of what modifications to the first order would be suggested if it was confirmed. I'm assuming, Ms McKee, that there's no difficulties with proper service of the second order, and any issues around the description of parties is now clarified.
There is no objection on that technical basis at all.
Yeah.
Just on the point, sir.
Yes, sir.
I had intended in the sort of legal contract between the council, the trust, and the tenant to just record exactly what was being compulsorily acquired. So that would be my record of what's happened.
Yeah.
But it might be helpful for your own point of view for that to be formally confirmed. This is how it all hangs together, plot by plot. Yeah.
Yes, I think that'd be very helpful. I mean, if I'm writing a report indicating how all of that would fit together, and just narrating the various technical issues about descriptions of fathers and sons tenancies and various things, if it were possible for you between you to include in your discussions and formally submit to me a kind of joint statement of agreed facts, then that can make it very clear to ministers. It will need to make it clear to ministers, although as has been pointed out, it makes no difference to the overall package which bit of the number 1 order would not be confirmed because of the subject matter of number 2 order. So just a sort of clarity from that point of view, I'm assuming I refresh my memory from the Avant Homes objection and their technical point related not to an issue of the narration of the parties in the schedule, but just who something was served on. I think they had a security over the property, and they made clear that potential defect was cured by their appearance.
Well, with respect, sir, there was no defect in the service of the notice on Avant. They weren't entitled to notice at the point they suggested that they were entitled to it. Okay. So I think they responded to that. But I think at the PEM, the first PEM, I think the parties did confirm that the technical issues regarding service were something that they were no longer pressing. Yeah.
I know, I agree. They did, and that was very helpful to me. But I'm just what I was going to say is I don't think that if any discussion between the trust and the council just being clear about what the order that sought to be confirmed, I don't think there's an Avant Home interest in that, and I just make that point simply because they've now withdrawn. So I don't think they need to be involved. So I'm agreeing very much with from that perspective. So that was the other point.
Sir, can I just come
of course, yeah.
Just for clarity, so that when Brodie's and myself negotiate this contract, the sort of the recital in the contract will set out precisely what is being CPO'd and what plots are being engaged. So we can either show you that, or that could form a quick joint minute that you could have a look at, so that you can use that.
Yeah,
that's okay, Jackie. That's okay, Jackie. That's.
I think a joint minute would be preferable, Alistair, but at least we're duplicating the work. Yep.
Yeah. Okay.
No, absolutely. No, that's very helpful. And the only other 2 things I had in my mind, again, I think we touched on this briefly with Jackie Maguire in the first meeting that we had. Was just containing in any further documentation just a sort of a confirmation from yourself or from a solicitor from Falkirk Council, just confirming that all the full intimation and advertisement requirements for the orders have been made. Obviously, I've not seen anything in relation to the second order yet, but just to get that, so I can narrate that and confirm in the order that I can satisfy myself that all intimation requirements were suitably and properly made, and having a basis to do that would be helpful. And the other,
when the papers do arrive, you can see that Mr. Blythe has prepared a report that covers that.
Excellent. That's absolutely perfect. And the only other thing, just again for completeness and thinking ahead of the report, is you've given an indication of some of the documents you'd intend or would have intended to rely on at a hearing, and that includes a number of committee reports. I think you had them as documents FC 32 and 33. I wonder, would you do that? You could just include in that confirmation of the date on which the council approved those reports, and that can just allow me to make a linkage through between the report and the due authorisation, and therefore the legal authority for the proceeding with the CPOs in due course. But that's obviously a very minor point.
We will confirm that. My understanding is that the dates on the reports will be the date of the date of the actual council meeting or
Good.
committee meeting at which the reports were considered and approved, but we can certainly confirm that,
Yeah,
and possibly just provide the minute as well, so that you have everything.
Yeah, that'd be good. If you could do that, that would just close that off, which is absolutely fine. And that actually, given the helpful discussions that parties have been having in recent times, they were the issues that I had in mind for discussion today. So I think the idea of giving parties around a 6-week opportunity. I don't know whether you want to aim to convene to have a further business meeting, or you just want to, between you, just give an update 6 weeks from today as to what the position is at that stage. I mean, it's no great bother to arrange another meeting, but it's obviously at the same time a bit cumbersome. We could arrange a meeting sometime around then, and then just not have it if it's not needed, if that would be easier for your diaries, because I'm conscious you're all very busy people.
I wouldn't want to be the voice of doom here, but I think it would be useful to have at least a diarised pre-examination meeting. I mean, there is always the potential that we can't reach agreement. I very much hope that wouldn't be the case. There's no reason to suggest that wouldn't be the case. Wouldn't be the case that we couldn't reach agreement. So, but I think just in the event that there were any problems or any delays, it would be useful to have a pre-examination meeting in the diary. As you say, we can always dispense with the need for it if we have reached settlement and the objections have been withdrawn.
Yeah, because it's 7 weeks, I guess that'll give you your 6 weeks plus a bit of time to cancel it and free up diaries. Mr. McKee?
That's fine. I'm happy with that arrangement.
Mr. Hall?
Yes, me too. Yeah, I'm
okay.
very happy.
Right, in that case, I'll get my office to arrange that and see if we can put a date in at that point. That'd be fine. Okay, well that was very helpful and very brief. 22 minutes past 10. I don't know if anybody else has any other issues they want to raise this morning.
No, sir.
I don't believe so.
Right. In that case, I'll close the meeting and thank you for the brevity and of your responses and the efforts you're making to try to achieve resolution of this. Thank you.
Thank you.
Thank you.